Um, so there we go, at least that worked. So welcome everyone on this panel discussion on access to justice for Palestinians in the occupied territories. We'll pay specific attention to the Ziada case. Definitely more about that later. First of all, I would like to introduce myself. My name is Thomas van Gool. I'm the project lead Israel-Palestine at PAX, Dutch peace organization, and one of the organizers of this event, together with the UvA Students for Justice and the Nuhanovic Foundation. Very happy that I can introduce the panelists of today to you. First, Professor Marten Zwanenburg, Professor of Military Law at the University of Amsterdam, who will mainly focus during this discussion on the legal implications of the Ziada case and the future of IHL. Secondly, Dr. Susan Power, she's based in Ramallah and head of the Legal Research and Advocacy at Al-Haq, Palestinian human rights organization. And Susan will mainly focus on the access to justice for Palestinians and the consequences of the Ziada case judgment. Just some housekeeping rules before we really go to the content. So the questions that you might have to the panelists can be posted in the chat, which you can find at the bottom of your screen, and they will be answered at the end of the discussion. So then we will have a Q&A. But please already put them in there during the chat or during the discussion, so we can already group them and make sure that we can answer them at the end. So as you can see, the cameras of the panelists are on and the others are off. So we would like to keep it that way, just for clarity and that people know who the panelists are. Yeah, so then I think I first give the word to Dr. Frederik de Vlaming, who will tell a bit more about the background of this webinar, the Ziada case and the Nuhanovic Foundation. The floor is yours, Frederik.
Okay, thank you very much, Thomas. Very happy to welcome you all here, unfortunately on Zoom, but it also means that we can reach more people around the world. Two things. The Nuhanovic Foundation is a foundation that supports victims of war who seek reparations for the damages, for the harm they suffered in a conflict zone through litigation. So we're a legal organization and we support people who would like to go to court to seek damages, to seek reparations, to seek restitution, compensation, acknowledgement of responsibility, of the truth. So that in general, that's our aim. How do we do that? First, we're a foundation, we're a fund. So litigation is expensive, is a costly affair. So what we aim is to assist victims who would like to go to court to seek finances, to assist fundraising, to cover costs of investigations or cost of legal representation, for example. What else do we do? We are a knowledge center, which means that we try to investigate and publish and develop databases with legal materials that may support litigation, support cases. If you go to our website, the Nuhanovic Foundation, you can see we have an extensive database on the Ziada case, which has all the legal materials, or almost all the legal materials. We summarize them. We in the case of Ziada, where all the legal materials are, or most of them are in Dutch, we translate them and make them accessible to academics, journalists, students, everybody who would like to know more about the case. I think that's an important issue. We stimulate academics to write about the case, also the media to write about the case, do more research on issues that are related to the case. So that's how we more or less, support cases on an intellectual way and also on a practical and a financial way. That, in short, is the Nuhanovic Foundation. Well, we support the Ziada case since 2018, when Ismail Ziada went to court, to a Dutch court. What is the case about? Very briefly, it is about the bombardments on Gaza in 2014, in the summer of 2014, where the family home of the family Ziada was hit, and the relatives of Ismail Ziada were killed. So it's a case about allegedly unlawful attacks on civilian population, or it is about house demolitions, and it's about killings of civilians in a armed conflict. Now, what is the problem? That it's very difficult, and Susan will further elaborate on that. That if you as a civilian or a victim of such breaches of international humanitarian law, you want to bring your case to court, that is very difficult in the context of the Palestine-Israel conflict. I will not say more about that. Susan will go into that, but that's actually the issue and the problem that becomes very clear here in the Ziada case. So what did Ismail Ziada do? He went to the Dutch court. There are two reasons for that. He's based in the Netherlands. He has a Dutch nationality, married to a Dutch citizen. And there is a rule that if there is no access to justice in the region where you're from, in the country where you're from, in the country where the crimes were committed or the breaches took place, then there is a possibility for the Dutch judge to take up the case. So that's why it ended up in the Dutch court. We're now in the appeals phase, and what is the focus of the legal proceedings until now is the question whether the military, the Israeli military that are the defendants in this case, enjoy immunity for the breaches of international humanitarian law that are on the table. That is so far has been the focus of the proceedings. That's what we're not going to discuss today, because that is an issue that we're going to discuss after the judgment that will take place on the 7th of December next week. We will discuss after the outcome. We will discuss with the lawyer, Professor Zegveld. We have no clue what will be the judgment, what will be the contents. But what today we will discuss is more about what is it about. It is about an attack. What in legal terms is at stake in terms of international humanitarian law. And that's why we're happy we're having Professor Zwanenburg here to discuss the international legal context in which we view the facts of the demolitions, the killings, the bombardment. So I'm very happy to have this substantial discussion today to better understand the judgment of next week. And I would like to leave it like that, Thomas.
Thanks a lot, Frederic.
Maybe Danielle or some of the students can put the link of our Ziada page on our website in the chat later on. I can also do it.
Thanks a lot, Frederic. Thanks for the very clear introduction. Very important. I think that there's some background before we make a start. Before I give ask the first question, I would like to say that it's of course a conversation between the panelists. So even if I direct the question to you, Professor Zwanenburg, Susan, feel free to respond, and also the other way around, right? If you want to react, please feel free to do so. So to kick off a question to Marten, Israel claimed to have acted in self-defense. Could it be considered self-defense, and what are the conditions for that? How does international law govern self-defense in occupied territories? Quite a big question, but good luck. You need to unmute. Yeah.
Thank you very much, Thomas, and welcome everyone. I'm glad to be able to contribute to this event on a very interesting case. And Thomas, you correctly mentioned that this attack that's at issue in the case took place during conflict in 2014. And for Israeli operations that were part of that conflict, Israel essentially put forward two justifications in terms of the jus in bellum. And before I say anything else, I think it's important to point out the distinction between jus ad bellum and jus in bello, which of course will be familiar to those among the audience who are in my IHL class. Welcome everyone. Jus ad bellum has to do with whether states are allowed to use force. So it has to do with things like the prohibition on the use of force and the issue of state self-defense. And jus in bello has to do with the legal regime of international humanitarian law. So a few words about the jus ad bellum issues here. Israel essentially seems to have put forward two justifications under jus ad bellum for the operation in Gaza. One was self-defense, and the other one was that this was part of an ongoing armed conflict. Israel's ambassador to the UN Security Council stated that Israel launched an operation of self-defense, referring to this particular operation. And so that seems to be at least one of the justifications that was put forward. Now let's take a look at both those justifications. And for self-defense, this of course is an accepted exception to the prohibition on the use of force, which is set out in the UN Charter. It's laid down in Article 51 of the Charter, and there are a number of criteria that need to be met for a claim of self-defense to be legitimate. Essentially, there needs to be first an armed attack. Second, the use of force needs to be necessary. Third, the use of force that is used needs to be proportional. And finally, the criterion of immediacy needs to be met. Now, the operation of which this attack was part was a special case because it took place in occupied territory in Gaza. And in that respect, it's interesting to look at what the International Court of Justice has said on a claim to self-defense in occupied territory, which it did in particular in its advisory opinion in the Wall case in 2005. And in that case, Israel claimed that self-defense was a justification for the building of a wall or a separation barrier, or depending on who you ask, it goes by different names. And the International Court of Justice essentially said that that claim was not, that claim could not be upheld for two reasons. One was that, according to the International Court of Justice, only states can carry out an armed attack. In this case, we're dealing with allegedly an armed attack by a non-state actor. And therefore, the International Court of Justice said there was no possibility for Israel to invoke self-defense. And the other reason that the International Court gave for denying the claim to self-defense was that the use of force took part in occupied territory, and the International Court of Justice categorized that as an internal use of force. Now, those findings by the International Court of Justice are not uncontroversial. So with regard to the question whether only states can commit an armed attack, there are a number of states that have publicly come forward to say that they consider that a non-state actor can also commit an armed attack. The Netherlands is one of those states. And the argument that the use of force in occupied territory is internal use of force, if you will, that it doesn't cross state boundaries is also controversial because it is difficult to square with the starting point of the law of occupation that occupied territory does not become part of the territory of the occupying power. So that's one justification. The other justification put forward by Israel was that the attack was part of an ongoing armed conflict, that the operation was part of an ongoing armed conflict. Now, there's some support in literature for the view that once an armed conflict starts, then the jus in bello is the only regime that we should look at, and the jus ad bellum no longer plays a role. And if you accept that proposition, then of course, as soon as there is an armed conflict, then we can put aside questions of jus ad bellum. Personally, I don't agree with that view. I think there's a strict separation between the two, between jus ad bellum and jus in bello. And therefore, even if there's an ongoing armed conflict, there still also needs to be a justification for the use of force extraterritorially under the jus ad bellum. So I hope that I've given you some elements to perhaps think about, and I'm sure there will be some interesting questions. So thank you very much, and back to you, Thomas.
Thanks a lot, Marten, Professor Zwanenburg, for this elaboration. You already mentioned it, the proportionality. I would like to zoom in a bit on that. There's a follow-up question: can the killing of civilians ever be considered lawful? And what does this principle of proportionality mean? Because it sounds like it's a very essential part of the case, or of the things that are needed. Could you maybe elaborate a bit more on that?
Yes, I'll be. It's my pleasure to do so, Thomas. And now, you made the step from the jus ad bellum to the jus in bello, because proportionality is both part of the jus ad bellum and the jus in bello. But in the context that you mention it, and whether civilians can be killed, and if so, under what circumstances that's relevant, then we're talking about the principle of proportionality in the jus in bello or the international humanitarian law sense. And there, essentially, I think it's good to start with another principle of IHL, which is the principle of distinction, which provides that civilians can never be attacked and that civilian objects can never be attacked, but only military objectives and combatants or members of the armed forces of an armed group or civilians who are directly participating in hostilities. So that's the principle of distinction, very briefly summarized. Even if something is a legitimate military objective and therefore there's no problem with the principle of distinction, the party that conducts an attack still needs to respect the principle of proportionality. And the principle of proportionality provides that, and here I'm going to read out to you, apologies for that, an attack which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated, that such an attack is prohibited. And what that principle thus essentially requires is that we, the commander who is going to conduct an attack, balances two values: military advantage on the one side and civilian harm on the other side. And I think it's important to stress a few points with regard to the application of that principle. One is that it would be very nice if we had a mathematical formula for balancing those two, but unfortunately there is none, not in IHL, and there's none outside of IHL. And so therefore, the standard that is applied is what a hypothetical reasonable commander would do in similar circumstances. So the commander has to decide, and whatever he decides is compared to what a reasonable commander would do. Another important point is that the commander has to make his assessment before he conducts an attack, and he has to do so based on the information that is available to him at the time. So information that comes to light after an attack has been conducted is not really relevant to applying the principle of proportionality. What is important is the information that was available before the fact. And then finally, I think it's important to stress that what the principle prohibits is attacks which are excessive, in which civilian damage would be excessive in relation to the anticipated military advantage. And excessive is something different than extensive. So if the military advantage is great, then that also means that there's more room for civilian harm. And conversely, if the military advantage that would be gained from an attack is anticipated to be small, then there's relatively little room for civilian harm under the principle of proportionality. So I'd like to leave it at that for now, Thomas, and back to you.
Thanks, very interesting indeed. Susan, I don't know if you want to respond, but maybe also what I would like to ask you, Susan, is, so now we talked a lot about IHL. So what happens in case a state violates IHL? So what are the steps? What happens?
Thanks a million, Thomas. Well, a few things can happen, really, if a state violates IHL. So firstly, the individual agents of that state may potentially be prosecuted for criminal acts under international criminal law. So there is the principle of individual criminal responsibility, and this was developed and established at Nuremberg. And we have a number of we've had a number of international tribunals established since, and of course the International Criminal Court. And under the Rome Statute as well, there can be individual criminal liability for individuals who've individual agents of a state who have committed acts of genocide, crimes against humanity, war crimes, or even potentially the crime of aggression So there are various legal avenues that can be taken, but of course, with something like the International Criminal Court, you would need, for example, for the state parties for the states to have signed and ratified the Rome Statute, and of course, if in our case, like the state of Palestine has signed and ratified the Rome Statute, so there is jurisdiction of the court, for example, over the occupied Palestinian territories in the West Bank, including East Jerusalem and the Gaza Strip. But there's also other avenues that can be taken potentially, and some are more difficult than others. So, for example, like when an agent of the state commits a criminal act, there can potentially be state responsibility for an internationally wrongful act. But here you would need attribution to the state of the internationally wrongful act, and this would need tests of effective control to be carried out. So there's various effective control tests, like the overall effective control test in the Tajik case, or the effective control trace from the Nicaragua case, but these are more difficult, and it's less likely that we would see, for example, like in a situation like the hostilities in Gaza, that we would see state responsibility for internationally wrongful acts and the types of reparations that we would be looking for and seeking in the horizontal legal order. But also states have obligations, and third states have obligations also to respect and ensure respect for the Geneva Convention. So potentially also, not only does the state have obligations, third states may also have obligations, and may also, again, under attribution and under the effective control tests, may also be potentially have responsibility for internationally wrongful acts. But what we're really looking at, and what we're always seeking, is for the individual actor, of the state and who represents the state to be held accountable. And of course, there is, like under the Geneva Conventions themselves, they provide for grave breaches under Article 146 of the Geneva Conventions, and there is like universal jurisdiction, or a type of universal jurisdiction under the Geneva Conventions as well. And individuals can be potentially prosecuted in national courts for these grave breaches. And states parties to the Geneva Conventions are also under an obligation to search for and prosecute individuals who've committed acts which amount to war crimes within their jurisdiction. So just in terms of where we are at the moment with individual criminal responsibility, like we've had quite a serious development in the last couple of months, where at the International Criminal Court, the International Criminal Court has moved to an investigation in the situation in the state of Palestine. And I think it was really key here that the prosecutor identified that there were members of the Israeli authorities and members of the Israeli military forces that may have carried out acts which amount to war crimes and crimes against humanity in the occupied Palestinian territory. And again, like when we're looking at, and I suppose we're looking at the case where, like a case where the state violates international humanitarian law, and just to point out that individuals are held accountable for these acts of the state. So we have acts amounting to war crimes, and those crimes are carried out, for example, and the chapeau of Article 8 highlights that these crimes are that war crimes are carried out where there's a policy or plan, or they're carried out in furtherance of committing these types of violations. And also, like with crimes against humanity, we have attacks against the civilian population. And again, these are widespread and systematic attacks against the civilian population. And these attacks are carried out at the level of the state. So there will be in the furtherance of a state or organizational policy to commit such an act. So what we're looking at here there's policies and plans at a state level. There's very serious state planning behind these types of very grave violations of international law. And then individuals can be held criminally accountable and criminally responsible And that's in the international, for example, at the International Criminal Court. But there's also other aspects in relation to civil claims against the state. And there's other mechanisms as well where in the domestic courts where potentially there can be accountability for individual violations. But of course here would usually be, there's procedural issues in relation to procedural immunities, and these types of issues can often follow the case. So there's customary international law immunities, functional immunities, and this is something that is difficult to contend with in these types of cases. I'll give it back to you, Thomas.
Thanks a lot, Dr. Power Susan, for this elaboration and this overview. When we look specifically at the case of Palestinians, so what are kind of the issues of taking these types of cases before the Israeli courts? Because that's kind of also essential in the Ziada case. Could you elaborate a bit on that?
Absolutely, and thank you for the question. I suppose to begin with, these types of cases, there's no justice before the Israeli courts. Like what we're looking at when it comes to Israel, that there's the Geneva Conventions are not directly incorporated into Israeli law. And also Israel actively works against the international legal processes. So even at an international level, when there's special rapporteurs who are investigating and monitoring and documenting violations of international human rights law, they're denied access and entry into the occupied territory, with all the fact-finding missions and the commissions of inquiry which have been established under the Human Rights Council. All of these investigators have been denied access into the territory by Israel, and they come into the territory usually through Egypt into Gaza. So Israel doesn't comply with these international mechanisms. And also more recently, it has denied visas to the staff of the Office of the High Commissioner for Human Rights. So when we're looking at access to justice in Israel, and especially for Palestinians in Gaza and victims of these kinds of atrocities like we saw in 2014, the only avenue is through the Israeli Military Advocate General. And the Israeli Military Advocate General is the chief legal advisor to the Israeli army and is also the legal advisor to the Israel Civil Administration. So the civil administration is the occupying authority. And then this person wears a dual hat. So they're the advisor to the army, and they're also in charge of the criminal investigations. And this is effectively the army investigating itself. So we've seen the damage and the result of this, which is essentially that there's no access to justice. So even in 2014, there was horrific hostilities on the Gaza Strip. I'm sure everybody's familiar with it, with 2,251 Palestinians killed, including 556 children. And throughout the course of the month, there was 31,000 civilian properties which were destroyed. So it was absolute annihilation in the Gaza Strip. So following this, there was a number of complaints which went through to the Military Advocate General. So there was over 500 criminal complaints that were issued, and of these 500 criminal complaints, there was only 3 which were finally investigated and resulted in indictments, and they were for the lowest level of criminality, for basically the petty theft and pillage by soldiers, ground soldiers who had stolen wallets and such forth in the Gaza Strip. So what we were really looking at is a complete shielding of the perpetrators of atrocity crimes in the occupied territory. There has been organizations on the ground, organizations that we work with as well here as Al-Haq. So Al-Mazan had submitted 122 criminal complaints as part of the complaints that were submitted. And of these, 72 were closed without investigation. There was another 18 criminal investigations opened, but these were subsequently closed. And then even 6 years after the attacks, there was 3 which remain pending, and they were never went any further. So those were the attacks on UNRWA, on the UNRWA building, which killed 20 people. There's also killing of a man on the 24th of July, and another attack on a 7-year-old boy who was denied and obstructed medical treatment by the Israeli occupying forces. So this is the kind of obstruction of justice that we see. The system was supposed to be reformed in about 2015, but again, we haven't seen any access to justice since then. So, for example, it's now subject to appeal before the Israeli Attorney General, and there was the fact-finding assessment mechanism established as part of this reform process. And this was supposed to kind of expedite and give and speed up the criminal investigations. But what we've seen is that there's 60 days to appeal to the Israeli Attorney General. But after this, the cases lie pending for even years. So there's these cases basically go to sink and to be forgotten about on appeal to the Israeli Attorney General. So it's very damaging, and there's no recourse to criminal justice in the occupied territory, and certainly none for those victims in Gaza and the victims of the 2014 attacks on the Gaza Strip.
Thanks a lot. Yeah, thanks a lot, Susan, for this bit of a grim picture. There's also, I think, a lot of similarities can be seen with the report that came out earlier today by Beth Salem and PCHR on the Great March of Return and the lack of investigations into that in 2018. So it seems like a trend. Also, like you already mentioned a bit about domestic courts and third state responsibilities, Geneva Convention, universal jurisdiction. So what are kind of ways that victims could invoke their rights, and how could they be compensated? Do you see indeed a role for domestic courts in that?
Absolutely, and I think I'll just preface this first with the problems that we have in the occupied Palestinian territory, and especially for victims in Gaza in particular, in relation to trying to get civil compensation in Israel. So the difficulty here is in relation to the Civil Wrongs State Liability Law of 1952. So basically, the main issue with this and the main impediment and obstacle is that in 2005, the Israeli Knesset, which is the Israeli Parliament, they amended the Civil Wrongs and State Liability Law of 1952, and this basically prevents people in conflict zones. So it would be all people in Gaza, all people in the West Bank, including East Jerusalem, prevents them from looking for liability and compensation from the state of Israel for violations of international humanitarian law and international human rights law carried out by the Israeli military. Now, there was in 2006 there was a challenge, a constitutional challenge to this law brought on by Adala, which is one of the human rights organizations based in Israel. And there was actually success in that court case, and the Israeli High Court of Justice at the time found that the provision was actually unconstitutional because it had granted an absolute immunity to the state in relation to these civil liability cases. But then fast forward to 2012, and we had this really horrendous amendment which was brought forward. So this is amendment number 8 to the Civil Wrongs State Liability Law. And amendment number 8, again, basically blocks Palestinians in Gaza and in the West Bank from bringing the civil claims before the Israeli courts, and it prevents claims related to combat situations, combat action, and to residents in enemy territory. And we know that since 2014, all Palestinians in Gaza are considered residents of enemy territory. So after Hamas was democratically elected in the Gaza Strip was declared to be hostile territory. And then in 2014, it was declared by Israel to be enemy territory. So there's no recourse and no legal avenues to get civil redress before Israel. So it's particularly problematic. And there was one case, and also just to note that this law, this amendment number 8, has been backdated back to 2005. So it was introduced in 2012 and then backdated. So all of those court cases that had been in the preliminary stages, all of those cases now can't go forward based on this retroactive law which was introduced. And there was one case in particular, one particularly heinous case called the Ataya. There was a young Palestinian boy, Ataya Al-Nahabin, and he had been coming home from school and was actually on his birthday, and he was shot. And due to his injuries, he's now paraplegic. And there was no hostilities ongoing. He was peacefully coming home from school, minding his own business, when he was shot and when he sustained these injuries. So the case was taken by Al-Mazan, and he's this was one of the cases which suffered from the retroactive effect and from the denial of access to justice. So even the Commission of Inquiry, they found that he was not eligible for compensation because he was from enemy territory. So this was brought up at the recent Commission of Inquiry conclusions by the recent Commission of Inquiry, which was looking into the Great Return March. And the Commission said that it was unaware of any alternative mechanism employed by Israel to compensate Palestinian victims for damage caused by, unlawfully caused by the occupying forces. And it also recommended that this amendment number 8 would be repealed. So this is just to highlight that there's absolutely no avenues to justice in Palestine, and no avenues either for any civil claims and any civil compensation. So it's really imperative and important that there is actually access outside and actions that are taken in third countries. What we've seen by and large is right across the board, there's the Palestinian exception. So every time Palestine and Palestinians try to look for justice elsewhere, the doors are closed, and even the laws are changed in different countries to prevent access to justice. And we've seen this in terms of the universal jurisdiction laws in Belgium. We saw it in relation to the state immunity laws, which were introduced with Livni's potential arrest in the UK a number of years ago. So this type of exceptionalism follows Palestinian cases wherever they go. But that's why it's so important, and this is why this particular case is so important, because this is a case, the Ziada case, of course, for the family and the compensation for the family, but all Palestinian victims are looking at this case because there's no justice for Palestinian victims, and justice for one family is actually justice for everybody, because everybody there's so much in terms of the public morale and what people need. And to have this case going forward at this time, it's given such an energy, and it's given such a sense of hope as well to everybody that there could possibly be some sort of justice and vindication for the absolute horrific atrocities from 2014. Thanks, Amos.
Thanks a lot, Susan, for elaborating on that and also highlighting the importance also in a broader picture, not just in this particular case, but also in providing a sense of hope. Then I want to ask, also looking a bit at the time, but I also want to ask Professor Zwanenburg, and maybe I also want to hear your answer, Susan, for the future legal implications of IHL. So do we have to rethink traditional IHL to adapt it to contemporary conflicts, you think? Make a bit of a bridge, but...
Thank you, Thomas. That's a very good question. There are, from time to time, and certainly in recent years, there have been many calls for rethinking IHL, either adding new rules or taking up new interpretations of existing rules, and certainly, especially with regard to the kind of conflicts that we're talking about, which are conflicts where there's much fighting in populated areas and where there are non-state actors involved, where at least some of them allegedly consciously disregard IHL, for example, by using civilians as as human shields. And those, especially those characteristics, have led to proposals to either change IHL or to reinterpret IHL. For example, some have argued that certain weapons that are now used in populated areas that are explosive in nature, that those should be banned, or at least that the use of explosive munitions in populated areas should be limited. And there's some diplomatic conversations on that ongoing, but so far that hasn't led to a change of the law. And on the other side, there are some who argue that, for example, non-state actors who regularly allegedly use civilians as human shields, that should lead to a situation in which persons who are used as human shields should weigh less. I know this sounds very blunt, but that's not my argument. That they should weigh less in terms of a proportionality assessment, because otherwise the non-state actor would profit from consciously disregarding the law. So those are some examples of where there are proposals for either changing the law or new interpretations of the law. Of course, new interpretations can always arise. Those are mainly based on state practice. With regard to new rules, we see that in recent years, it's very difficult for states to come to agreement on new rules. And that brings me to a bridge with the issue of compensation or more broadly, enforcement of humanitarian law. A number of years ago, there was a process initiated by Switzerland and the ICRC, which was aimed at trying to see whether enforcement mechanisms of IHL could be strengthened. And unfortunately, that process was unsuccessful because a number of states were just not willing to really go there. Unfortunately, it seems that it's very difficult to agree for states on new rules on IHL. At least under the current circumstances, it's still states who actually make IHL. So there's not much progress being made there at the moment. Thank you.
Thanks a lot, Professor Zwanenburg. Dr. Powell, anything to add to that?
Not much to add to this. But just for us in the occupied territory, and I know there's so many different areas, of course, where there can be development of the law. But for us, we just need the existing law adhered to and implemented, and for there to be enforcement. Like even the state of Palestine has ratified many international treaties and immediately ratified the Geneva Conventions and the Hague regulations, and there's such a level of respect in the state of Palestine for the international treaties. But what we've seen is Israel just completely being given a green card by the international community to violate international humanitarian law for decades. And the issue here is one of international responsibility, and it's one of collective action and the need to act at a Security Council level as well to intervene to prevent these violations of international humanitarian law, which are ongoing. One thing which we would, one area which we think would need maybe reassessment is the issue of the legality of the occupation and whether an occupation is legal or illegal. And for many years, of course, in contemporary practice, there is like occupation is just a question of fact, and a question of fact under the Hague regulations under Article 42. There has been moves here, and especially with the special rapporteur of the occupied territories, that this particular occupation has actually crossed red lines into illegality, and should be characterized and considered an illegal occupation. And that is because the occupation is one which is actually a colonization and an apartheid. And what we're seeing is an expansion and a continuing colonization. And these practices, and along with de facto and de jure annexations, de facto annexation in the Jordan Valley, de jure annexation of of East Jerusalem. So these are very problematic components, and it's very obvious right now to everybody on this call that this is not a temporary occupation. This is not the type of occupation that we would have expected to end in 2 or 3 years. This is a prolonged, permanent occupation of the Palestinian people. This is a permanent denial of their rights, and this is a permanent persecution of the Palestinian people. So we need to really address and look at what are we dealing with here. This cannot be looked at as just a question of fact, as an occupation, which is just an assessment of fact in this temporary kind of limbo where Palestinians are subject to decades of military rule as some sort of subhuman beings. So we need to address this and look at actually the occupation itself has a criminal nature, and the occupation itself is in its entirety an illegal occupation. So this is something that we'd like to see move forward in terms of the development of the law, that there are illegal occupations.
Thanks a lot, Susan. An important addition, I believe. Then jumping again ahead of the Ziada case and the judgment on the appeal. So what do you think would be the consequences for access to justice if Ziada wins the case? So not only for Ziada itself, but for victims, Israel, other cases, other courts, and also what would be the effect on human rights defenders if Ziada wins the case? Could you maybe elaborate a bit on that, Susan?
Well, we're all watching with bated breath here, because there has been no access to justice, and we have just decades of denial of justice. So if this case were to go ahead, I think we would see like potentially more cases like this, and maybe a renewed respect and interest in the legal processes as well. But we also are waiting with kind of bated breath, because we know what Israel does when there is a successful case, and when there is, and we know the impact and the knock-on effect on human rights defenders, and possibly as well also the Ziada family who might be subject to the kind of smear campaigns and the type of targeting that we've seen by Israel. And I say this because, like, right now in the West Bank, our organizations are taking like communications to the International Criminal Court, and we have been targeted as human rights defenders. Our organizations have been slurred and outlawed as terror organizations. Our staff have had death threats for making the communications to the International Criminal Court. And there's been a whole series of really horrific and disturbed attacks by Israel, including attacks on our funding as well. So we know what the consequences are when we go down these legal avenues. Israel does everything in its power and possibility to try and cut the wind out of our sails. So we do, but this doesn't stop us, and it shouldn't stop anybody. The only proper and sound avenues and sound avenues towards peace are going through the legal mechanisms and going through these types of cases like the Ziada family. And this is why we have to support them and ensure that these cases continue, and ensure cases continue for these types of civil claims, and also for criminal prosecutions as well. Because it's only through justice will we come to peace. There's the violence only breeds violence, and we can't go down those lines. We're already decades and decades into this. So we're looking to continue the respect for the rule of law and the respect for these kind of processes, regardless of the kind of intimidation and attacks that Israel throws our way.
Thanks a lot, Susan, for the powerful words. Then I would like to move on to the Q&A. I've had a lot of other questions prepared, but because we also want to give the audience a chance to ask questions. I already saw a lot coming in, so please keep them going. The first one to Professor Zwanenburg. Is a reasonable commander understood to be a reasonable commander from the perspective of the state actor in question, or is there any supra-state standard characterizing a reasonable commander? In practice, it seems always to be left to the determination of the party whose conduct is being scrutinized.
Well, thank you. That's a very good question. I would say that, well, let me start by saying that the reasonable commander standard is something that has been, that follows from the literature and from state practice and from court judgments, and it's not something that is laid down in any treaty. So if only because of that, there's there's not very much clarity on what it means. I would certainly say that it's a supranational standard in the sense that it doesn't just, the standard of comparison is not just other commanders from the same state, but all commanders around the world. What would they do in a similar situation? And of course, because of the vagueness of the principle of proportionality, there is you could say perhaps a zone of reasonableness, some have called it there, with an upper limit and a lower limit, and whatever commander decides needs to be within that zone of reasonableness. Of course, another aspect is who are you asking, and who is making the determination, who is assessing whether what the commander did was reasonable or not. And there, of course, that may matter a great deal. It may be persons from the same armed forces, the commander of the commander who made an assessment on proportionality. It may be a public prosecutor, for example, in the Netherlands. Every time that the military uses force, then report goes to the civilian public prosecutor, and the public prosecutor will then make an assessment. So that then the public prosecutor will make an assessment based on his or her views. And of course, yet another situation would be where there is a court which needs to make a determination, and there the court may take into account any circumstances that are of particular relevance for that court. And a court may, for example, call up expert witnesses, may call up another commander and ask that particular commander, well, is this something that you find reasonable that you might have done under the same circumstances? So yeah, unfortunately, there's no mathematical formula, not one black and white answer, but I hope this is helpful nevertheless.
Thanks a lot, Professor Zwanenburg. And a question to Dr. Power. How are governments of other states addressing this issue and regarding this case? What would it implicate if the Dutch court starts holding responsible Israeli officials? Could that facilitate governments to take a stronger position on the access to justice issue?
Well, we would certainly hope so. But again, these types of cases, or even want to highlight that this is so unusual and they're nearly so exceptional. Because like the link that we had here was with the Dutch nationality. So we had that linking, and what we're really seeing is actually we're actually seeing this kind of restriction on these types of cases. It's very hard for us to even find established jurisdiction to bring these types of cases forward in third countries. So I think that's why there's so much even writing on this particular case, because there was all those various elements which came into place. So while we would hope that there would be other jurisdictions that we could take potential cases, the reality is that it's not that easy. If that's to give a very short answer to that.
Thanks a lot, Susan. I think it's a good answer. Then there was a question about what about customary into IHL? This brings us closer to addressing difficult issues, because we didn't really discuss that yet. Do you want to go into that, Professor Zwanenburg?
Yes, I'll be happy to. I did briefly mention customary international law, and customary international law is very interesting because it can mean that a state is bound by a certain obligation, even if it's not bound by that obligation as a matter of treaty law. So in that sense, it can be helpful, and in fact, there are many rules that, as a matter of treaty law, only apply in international armed conflicts. So conflicts between states that are recognized to also apply to non-international armed conflicts. So conflicts in which one party is a non-state actor, as a matter of customary international law. And but there are two difficult issues here, which mean that I'm afraid this is not a panacea for difficult issues. One is that in order to determine that something is a rule of customary international law, we have to establish that there is broad state practice which follows that rule. And secondly, we have to establish what is called opinio juris, which means that states follow that practice not just because it's politically convenient, for example, but because they consider that they have to do so as a matter of law. And that, of course, can be quite difficult to establish that there is that state practice and that there is that opinio juris. Another difficult issue is that there's the issue of so-called persistent objectors. A state which, during the formation of a rule of customary international law, persistently objects to that rule. So it says that that rule may be forming, but I don't want to be bound by it. I don't consider it's a rule of customary international law. That state will not be bound by a rule of customary international law. So let's take, for example, if Israel, during the formation of a rule of customary international law, persistently objects to that rule, then it would not be bound by that rule as a matter of customary international law.
Thanks, very interesting and relevant. Then a follow-up question. You mentioned it also to Professor Zwanenburg, you mentioned the defense of Israel in the Ziada case, looking at how the Israeli Supreme Court found in the recent case of Dr. Izzaldin Abu Alish, dating to a 2009 strike in Gaza, that acts of war prevented his claim to be in the jurisdiction of the court. Do you think that it could influence the Dutch court to find that there is no available domestic access to justice?
That's a very good question, but I have to admit that it's one that I find very difficult to answer because to some extent it involves looking in my crystal ball, and I don't have one. And it also goes to more procedural aspects of Dutch civil law, of which I'm afraid I'm not an expert. As Dr. Powers explained, it may be relevant for courts that there's no access to justice in another place. So it might be, but as I said, I find it very difficult to say. And anyone who does have a crystal ball, then please tell me.
Susan, not sure if you want to add something to this. Thanks, Professor Zwanenburg.
Yeah, I don't really have anything. I don't really have anything further to add to the question, but I did see another question down here, which I was kind of half thinking about, and it's in relation to whether the Ziada case helps other domestic cases succeeding with the ICC investigation and moving the investigation forward. So I thought that was a really interesting question to ask, especially where we are as well with the Ziada case, and hopefully this case is successful, you know, and the case does move forward and succeed in the appeal in relation to the issues around functional immunity. But like, it does raise interesting questions in terms of complementarity and what will happen with the International Criminal Court. So like potentially this case, because we've submitted many files to the International Criminal Court, and they know the office of the prosecutor, and there's particular focus at the moment, like looking at crimes that have been committed in Gaza. So potentially, and during 2014, so potentially, like this case in particular, like might not be examined at the International Criminal Court with taking into assessment like the complementarity principle. But there's other cases then that could go forward, and I don't think it's any reason to not proceed. And as well, like the International Criminal Court, it's such a long process, and there's going to be so very few cases which are examined in the end and which are pursued. that we really need. So it's only going to be like, there'll be a few victims who'll have access to justice even there, because the court is going after like the big fish. So like all of these, every single one of these cases, including the Ziada case, they have symbolic value as well, you know, because there's so many hundreds and thousands actually of Palestinian victims who aren't going to have access and recourse to justice. So all of these cases are so important for everybody. They're nearly a case. This case is a case for the whole of Palestine, and it has that kind of symbolic value behind it. But in terms of moving things forward at the International Criminal Court, like we wouldn't see any, we wouldn't see this case as having any impediment to the proceedings and to the investigation. I don't even like to think about what happens, you know, if the appeal is lost, but just says put the shoe on the other foot. If the appeal was lost, then we can also show, you know, that there is absolute, complete impunity for Israel's crimes, and that there's no avenues, even in third states, for criminal and for civil actions. And this can, and again, this can show, I think it can show in a way, and it can add to the fact that there is actually no recourse to justice anywhere for Palestinians, and it adds to the issues and the necessity to push the investigation forward. But I think that it's important. But we really hope that this case wins on appeal.
Thanks a lot, Susan. Also, thanks a lot for taking that question. I also indeed found it a very interesting one, and an argument that's often used, right, that you hear quite often. So good to hear your views on that. I see we are already took a few minutes longer, so I think we should leave it here. There was one very interesting question about why it's a civil case and the choice has not been made to make it a criminal case. So I think indeed, like as Frederic also pointed out in the chat, it's a very good question for the 9th of December, when there will be comments on the judgment by Ziada's lawyer, Professor Lisbeth Zegveld. So everyone is also more than invited to join that session. Registration will follow later. And as Frederic also mentioned at the beginning, on the 7th of December, there will be the judgment of the Hague Court of Appeal at 10 o'clock in the morning, if I'm not mistaken. So also you're invited to join that live, not online. Yeah, and then of course, by finalizing, thanks a lot to our speakers, Professor Zwanenburg, Dr. Power. Thanks a lot for sharing your insights. I think I hope at least also for the audience was very interesting. And also thanks a lot, Roger Waters, for the comment in the chat. Great to see that you are here and with us and following the case. And thanks a lot. Hope to see you all soon at a different occasion.
Thank you, Thomas. Thank you, everybody.
Thank you so much. And I saw Roger Waters was on the call as well. I'm a huge fan.
Good. You will see him hopefully next week again.
Fantastic.
Hope to see you all back on the next week 9th if we talk to Professor Zegveld. Thank you for coming. Thanks, Thomas.